In 1973, a woman named Lily Gray was driving a Ford Pinto on a California highway when another car rear-ended her at low speed. The Pinto's fuel tank ruptured. The car burst into flames. Lily Gray died. Her passenger, a 13-year-old boy named Richard Grimshaw, survived with burns across 90% of his body. In the subsequent lawsuit, something extraordinary happened. The jury was shown an internal Ford document. The document was a cost-benefit analysis. Ford had calculated the cost of fixing the Pinto's fuel tank design, which its own engineers had flagged as dangerous, against the projected cost of paying out death and injury claims. The fix would cost $11 per vehicle. Multiplied across 12.5 million vehicles, Ford calculated the total cost of fixing every Pinto at $137 million. Then, Ford calculated the cost of not fixing it. They assigned a dollar value to each expected death: $200,000. To each serious injury, $67,000. To each vehicle, $700. They projected 180 deaths, 180 serious injuries, and 2,100 burned vehicles. Total projected payout, $49.5 million. $49.5 million was less than $137 million. So Ford did not fix the tank. That document became known as the Pinto Memo. It is the most explicit evidence ever produced in an American courtroom that a corporation had calculated it was cheaper to let people die than to make their product safe. And it was not the last time. Welcome back to Guilty and Free. The Pinto Memo did not teach car companies that this calculation was wrong. It taught them to stop writing it down. Because the calculation itself, the decision to weigh the cost of a safety fix against the projected cost of deaths, did not end in 1973. It continued. It continues today. Here are 7 cases where car companies made that calculation, chose the cheaper option, and the cheaper option involved people dying. Case 1. Ford Pinto, the $11 fix they wouldn't make. The Ford Pinto was introduced in 1971 as a small, affordable American car designed to compete with imported vehicles. During pre-production crash testing, Ford's own engineers identified a critical defect in the fuel tank design. The tank was positioned behind the rear axle, leaving only 9 to 10 inches of crush space between the tank and the rear bumper. In rear-end collisions above 25 miles per hour, the tank was likely to rupture. If it ruptured near a spark source, which rear-end collisions frequently produced, the car would catch fire. Ford knew this before the car went on sale. The fix was straightforward: a plastic shield between the differential and the fuel tank. Cost per vehicle, $11. Ford ran the cost-benefit analysis documented in the Pinto Memo. They concluded fixing the vehicles was not cost-effective. The Pinto went on sale without the fix. Between 1971 and 1978, an estimated 500 to 900 people died in Pinto fires. Estimates vary by source. Ford disputed the higher figures throughout litigation. In 1978, Ford issued a recall. By then, the National Highway Traffic Safety Administration had opened a formal investigation. The Pinto Memo had been leaked to the press, and public pressure had made the recall unavoidable. In the Grimshaw versus Ford Motor Company case, the jury awarded $125 million in punitive damages. At the time, the largest product liability award in American history. The judge reduced it to $3.5 million. No Ford executive was ever charged with a criminal offense. The engineer who designed the fuel tank continued his career at Ford. The author of the Pinto Memo retired with full benefits. Case 2. General Motors. The ignition switch that killed 124 people. In 2014, General Motors recalled 2.6 million vehicles fitted with a defective ignition switch. The switch could move out of the run position during driving, particularly if the driver had a heavy keychain, cutting power to the engine, disabling the power steering, and, critically, preventing the airbags from deploying in a collision. GM's own engineers had identified the defect in 2001, 13 years before the recall. Internal documents showed that engineers had discussed the defect repeatedly across more than a decade. The switch did not meet GM's own specification for the amount of force required to stay in position. There were multiple opportunities to fix it. In 2002, a proposed fix was considered and rejected because it would have delayed production. In 2005, an engineer changed the design of the switch, increasing the detent plunger spring without changing the part number, meaning the changed and unchanged parts were indistinguishable in GM's records. This created 13 years of confusion in subsequent investigations about which vehicles had which switch. The defective switch was linked to at least 124 deaths. GM's internal investigations, conducted before the public recall, had identified 13 deaths. GM did not recall the vehicles. In 2014, GM paid $900 million to resolve a Department of Justice investigation and entered into a deferred prosecution agreement. No GM executive was criminally charged. The engineer who changed the switch design without changing the part number, a decision that investigators later described as central to the cover-up, settled a civil case. He was never criminally charged. The 124 families received settlements averaging approximately $1 million per death. GM's revenue in 2014 was $155.9 billion. The $900 million fine was 3 weeks of revenue Case 3. Takata. The airbags that became shrapnel. Takata Corporation was a Japanese automotive parts manufacturer that supplied airbag inflators to virtually every major car company in the world. The inflators used a chemical propellant called ammonium nitrate to rapidly inflate the airbag in a collision. Ammonium nitrate is unstable under certain conditions, particularly exposure to heat and humidity, cycling over time. When an unstable Takata inflator deployed, it did not just inflate the airbag. It exploded, sending metal fragments into the face, neck, and chest of the vehicle's occupants. Takata's engineers had identified instability issues with the ammonium nitrate propellant as early as 2000. Internal testing in 2004 produced anomalous results, inflators that behaved unexpectedly. Rather than report the findings, Takata employees were directed to delete the test data and dispose of the samples. Delete the data. Dispose of the samples. And keep selling the inflators. The Takata airbag recall became the largest automotive recall in history, affecting over 100 million vehicles across 19 manufacturers worldwide. At least 27 people were killed by Takata inflators globally. Hundreds more were injured, many seriously. Takata pleaded guilty in 2017 to a single count of wire fraud and paid $1 billion in penalties. The company then filed for bankruptcy. The 3 Takata executives named in the criminal information were Japanese nationals. None was extradited. None served prison time in the United States. The car manufacturers who fitted Takata inflators, including Honda, Toyota, Ford, BMW, and others, were not charged. Case 4. Mercedes-Benz, the European defeat device. Volkswagen was not the only European manufacturer using defeat device technology. In 2019, the German Transport Authority, the Kraftfahrtbundesamt, ordered Mercedes-Benz to recall approximately 774,000 vehicles fitted with software that regulators determined was a defeat device. The software reduced emissions control system performance outside of specific temperature ranges, meaning the car ran cleaner at test temperatures than at the temperatures typical of real-world driving in Northern Europe. Mercedes-Benz disputed that the software constituted an illegal defeat device, describing it as a permitted thermal window designed to protect engine components. The dispute went to the European Court of Justice. In 2023, the ECJ ruled against Mercedes-Benz, confirming that the thermal window software was unlawful. Mercedes-Benz agreed to pay 2.2 billion euros in a settlement with German prosecutors, without admitting wrongdoing. No Mercedes-Benz executive was charged. While the investigation was ongoing, Mercedes-Benz continued selling vehicles in Germany. The CEO during the period of the alleged violations, Dieter Zetsche, retired in 2019 with a pension of approximately 4,700 euros per day. He was not investigated. Case 5. Firestone and Ford Explorer, the tire that killed 271 people. In the late 1990s, Ford Explorer SUVs fitted with Firestone Wilderness tires began experiencing a pattern of tire tread separation, the outer layer of the tire peeling away from the steel belt beneath at highway speed. When tread separation occurred at speed, drivers lost control. The Ford Explorer's high center of gravity made rollover likely. People died. By 2000, the death toll linked to the tire failures was approaching 200. By the time all litigation was resolved, at least 271 deaths had been attributed to the defect. What the litigation revealed was that both Firestone and Ford had data suggesting a problem years before the public recall. Ford had data from international markets, particularly Venezuela, showing elevated tire failure rates on Explorers as early as 1997. Ford did not issue a U.S. recall. Instead, it quietly arranged replacement tires in the affected international markets without disclosing the issue to American regulators. Firestone had its own internal quality data, showing elevated failure rates from its Decatur, Illinois plant, the primary source of the defective tires. The recall, when it finally came in August 2000, covered 14.4 million tires. Congressional hearings followed. Executives from both companies testified. Both companies blamed each other. Firestone paid $7.5 million to settle federal safety charges. Ford paid various civil settlements. No executive from either company was criminally charged. The safety data that existed years before the recall, from Venezuela, from internal quality records, from early American incident reports, did not trigger a single criminal investigation. Case 6. BMW and the diesel scandal extension. BMW has faced regulatory investigations across multiple European jurisdictions for emissions software that, like Volkswagen and Mercedes-Benz, produced cleaner results during testing than during real-world driving. In Germany, BMW paid 8.5 million euros in 2019 to resolve a prosecution related to irregular emissions practices, a fine that critics noted was far below the legal maximum and bore no relationship to the company's revenues. In the United States, BMW paid $18 million in 2021 to settle SEC charges that it had inflated retail sales figures by maintaining a pool of vehicles registered as sold that were not actually sold, a practice designed to present consistent sales growth to investors. Two separate frauds, two separate settlements, two separate jurisdictions. No admission of wrongdoing in either. No BMW executive charged in either. BMW's annual revenue, approximately 142 billion euros. The combined fines, approximately 26.5 million euros. That is 0.019% of 1 year's revenue. Case 7. GM and the Cobalt, the decade of denial. This case returns to General Motors because the ignition switch scandal was not a single failure. It was a system. In the decade between GM engineers first identifying the ignition switch defect in 2001 and the public recall in 2014, the defect was reviewed internally at least 6 times. Each review concluded it did not meet the threshold for a safety recall. The threshold, in practice, was not safety. It was liability. GM's internal review process, later examined in exhaustive detail by a former U.S. attorney appointed to conduct an independent investigation, found that the company had a systemic culture of avoiding liability acknowledgement that consistently prioritized legal exposure over safety action. The independent investigator's report, known as the Valukas Report, is one of the most detailed forensic examinations of corporate safety culture ever published. It found that engineers who raised concerns were not disciplined. They were simply not listened to. It found that the phrase "does not meet GM standards" was used to describe safety issues, a formulation that lawyers had determined was less legally dangerous than the word defect. It found that meeting minutes were routinely stripped of language that might create legal exposure. The language that was stripped was the language of danger. This was not negligence. This was a system for not knowing, for structuring information flow in a way that allowed executives to remain technically unaware of facts that lawyers had determined should not reach them. It is, as the Valukas Report concluded, exactly the kind of organization that produces disasters without producing accountability. 7 cases, decades of data, hundreds of deaths that were projected, calculated, and accepted as the cheaper outcome. The Pinto Memo is famous because someone wrote the calculation down. But the calculation does not require a memo. It lives in every product liability framework, every actuarial model, every cost-benefit analysis run by every legal department of every company that makes a product that can harm a person. The question is always the same. Is the cost of fixing it more or less than the cost of the claims? When the answer is less, the fix does not happen. And the people who die in the interval between that calculation and the eventual recall are not accidents. They are the cost of doing business. Priced in, planned for. And in almost every case on this list, not prosecuted. This is guilty and free. 7 car companies. Hundreds of deaths. Not one executive imprisoned for the decision to let them happen. Subscribe. New video every week. The next video asks the question none of the companies on this list want answered. What happens when you remove the liability cap? They got away with it because the math said they would.